Good morning, friends. The judgment which I am going to share with you would definitely help the aspiring political advocates who want to reach a high post in their political party or even want to become ministers, or including those who are aspiring to be elevated in the judicial system. Master degree holders, those who are interested in international law, is a case where the authority of the legislative assembly, whether is subject to questionable, revisable within the article 142, and the powers conferred on the privilege given to the assembly under article 212 and 208 were being discussed. Actually, a BJD whip of Bihar Assembly. Initially, there was a coalition government by Nitish Kumar with Congress, and thereafter Nitish Kumar has changed and allied with BJP, again became a chief minister. This BJD MLC member seems to have abused chief ministers, calling him with so many body shaming languages. Forget about that all are all available at paragraph 2.3. So therefore there was a motion to take action against him. Ethic committee was formed, and ethic committee called him, hold an inquiry, and finally recommended that he has committed unethical activities. Therefore, he was removed from MLC post permanently, and notification was also issued. Thereafter, the fresh notification for election was also issued. So the Dr. Sunil Kumar Sinha, who was expelled MLC, approached Article 32, because they can very well directly go to Article 30 if fundamental rights are breached. So Supreme Court, AR 2025, Supreme Court 1276, AR 2025 1276, Dr. Sunil Kumar Singh versus Bihar Legislative Council, represented by Secretary and others. So they have categorically held the privileges given under Article 211 and 208 are something different. It is the courts are not supposed to interfere with the illegal procedure and illegal any proceedings. But however, since after ethics committee recommendation, the assembly removed him, this is an administrative action. They said it is an administrative action. Therefore, a power of reviewing under doctrine of proportionality, the Supreme Court has set aside, not set aside, they said the period already undergone by expulsion is sufficient and is directed to be re-inducted as a MLC. My dear friends, the judgment deals with the paragraph from 46 onwards, international jurisprudence about doctrine of proportionality. And prior to that, the Supreme Court also categorically, what all are the fields where doctrine of proportionality could be attributed. They say service and labor laws, then administrative law, then constitutional law, then criminal law. They have said that these things could be applied. So far international jurisprudence is concerned, the doctrine of proportionality is widely applied in foreign jurisprudence. Germany jurisprudence discussed at paragraph 47, then 49 European Union, and they say albeit and LRM test and manifestly applied in disproportionate standard are often used as alternative rather than in conjunction. This is what paragraph 51 discussion. Then United States of America, that all these things were discussed. They say scrutinizing the action of the House role of Constitution of India has been discussed in Ashish Shekhar Supreme Court judgment. All these things after finally they say, so you take it, the ratio was that once after holding some proceedings, initiating proceedings, once passes any order, authority, any administrative order like removal, other things, then automatically the Supreme Court can invoke under Article 32 read with 142 of the Constitution of India. It's all right for time being. This is the judgment, and you should understand this judgment with very care. Read every paragraph. The allegations against the chief ministers by the Sunil Kumar Singh was, he says, Palturam. Then he says he is an expert in manipulation. Just like a snake sheds its skin every year. All these things are had spoken against the chief ministers Nitish Kumar. This is Bihar politics, and they at the paragraph E1 they say under Article 212(1) of the Constitution, since argument strikes all the core of instant matter, we find it imperative to address this contention at the very outset. Article 212(1) of the Constitution asks any inquiry regarding any proceedings in the legislature on the grounds of alleged irregularity of procedure. So for that they have come to say that proceedings in the legislature on the ground of procedural irregularities is something different than the validity of the action taken by the legislature, which may encroach upon the fundamental rights of the members and citizens. So they say when you have removed him, that legislation decision on the other hand is the culmination of legislature procedure, expression of the will of the House on a given matter, while proceedings of the legislature provide framework within which members exercise their deliberative function. The legislative decision is an authoritative determination that follows such deliberation. This decision of legislature, though emanating from coordinate branch of the government, are not immune from scrutiny by constitutional courts. So this is what they say. This is so far what I understand. To make you to understand, these all are the words most important. And when they discuss about the foreign, they also said domestic sphere. Doctrine of proportionality in Indian jurisprudence is guided by the principle of selecting the most appropriate and least restrictive measures to achieve the intended objective. The court's role is limited to ensure a proper balance between the adverse effect of an action or penalty on individuals' rights. They have said they have given proportionality punishment should, while considered, they say a degree of obstruction caused by the member in the proceedings, whether behavior of the member has brought disrespect to dignity of the entire house, previous conduct of the erring member, the subsequent conduct of the erring member, such as expressing remorse, cooperation with the institutionality scrutiny mechanism, availability of lesser restrictive measures to discipline the delinquent member, whether crude expression uttered are deliberate and motivated or a mere outcome of language largely influenced by the local dialect, whether the measure adopted is suitable for furthering the desired purpose and balancing the interest of society, particularly the electorate, with those of the erring members. So these all are the guidelines they have given to the under Article 142 to all the legislative assemblies, including Parliament, at the time of punishing any member these guidelines may be looked into. Best wishes.